law several routes at the disposal of suits effectively. A very recent addition to the criminal law space has been plea bargaining. And that is what we'll be discussing today on Law Express. My name is Noella Seidu. We'll go for a quick commercial break. When we return, you get to meet my co-panelists, and then we take on the topic, plea bargaining. Don't go away. This is Law Express.
Courage A. Asabagna. Courage Asabagna is a private legal practitioner whose interests go beyond the law. When he's not working, he enjoys watching football and listening to all kinds of music. Mumin Mashood is a private legal practitioner who enjoys a variety of hobbies outside of work. He enjoys watching football and reading for intellectual stimulation, delights in cooking with his wife, and finds relaxation in playing video games. Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
The aspect of plea bargaining is very important in the life of the Ghanaian citizen. This concept of plea bargaining had been in existence since time immemorial. However, it is scattered all across our various laws. Now, it has all now been combined now and become as an amendment to the criminal procedure. This plea bargain is important in the sense that it affects the life of an accused person, it affects the lives of a complainant, as well as it has an impact on the state at large. Now, what we need to understand is, what then is plea bargain? Plea bargain to a layman is to simply say that it is a judicial process where an accused person negotiates to relinquish his right to go on full trial in exchange for either a reduced sentence or some other benefits. There are so many things that can come across when we are dealing with plea bargain. Okay. But this is a 3-way kind of negotiation. The accused person, the prosecution, and the complainant.
Before you proceed on this, yes. To explain further what plea bargain or the plea bargaining process hinges on, we're looking at you deciding that, that you want to take responsibility for your actions, right? In a way that you choose to cut to the chase. So whereas you'd have had a full trial, you negotiate to just say, look, I'm guilty, and then you agree on some terms. So could it be likened to this consent judgment in civil proceeding?
Technically, one may say, on the face of it, it's easier to say so. Technically, one may say, no, looking at the nature and scope of how consent judgments are.
Okay. Yes. And the possible outcomes.
Yes, the possible
variety.
Outcome.
Yeah.
But like he explained it, if you look at our Constitution by virtue of Article 19, you are presumed innocent until proven guilty.
Yeah.
Which means that you have a right to proceed on a full trial, which requires prosecution to what? Prove beyond reasonable doubt that you are indeed what? Guilty or otherwise. So the concept of plea bargaining then comes in, that is to say that, look, instead of us going on a full trial, you kind of try to relinquish that right of going on a full trial in exchange for a benefit. But if you look at the thinking behind it, it's very simple. It saves the state time. In if we have to go on full trial, 2 years, 3 years, we are still, it saves cost. You, the accused person, you have to pay for a lawyer, moving up, going to court all the time. It reduces the number of cases at the court. So our court is already overburdened with cases. At the same time, it reduces what? The number of people at what? In cells or in prisons. It's a way to decongest our prisons and all that. So it's a novel way of trying to make our criminal justice system work or function in a better way. Now, if you look at the concept of plea bargaining, there are several aspects of it. You may look at it as a charge bargain, or a fact bargain, or a sentence bargain. So, I break into your house, I steal, I assault you. When I'm arrested, instead of me going on a full trial, I may decide to plead guilty. And to save the time of the state and my time, the state may decide that, okay, they are going to charge me for just the stealing and leave the assault and me breaking in.
Okay.
So that is a charge bargain. Then you can have what we call a fact bargain. That they will decide the facts that have to be presented to the court. So they are not going to say that I stole your car or your money, or they'll keep that aspect out. So we bargain on the facts.
Okay.
Then the sentence. Some of us going on a full trial, we decide that, look, once you decide that you are guilty, okay, let's agree on 7 years. And we present that to the court. So these are the 3 layers of plea bargaining.
We would come back to these layers,
Yes.
and then we'll rewind to where an arrest has been effected, who initiates the process, and all of that. But didn't this already exist by virtue of guilt by admission? So before, already in our criminal jurisprudence, we had that opportunity where an accused person could admit guilt. Yes, you didn't have the option to negotiate the consequence, but of course, the judiciary or the bench would consider that in the sentencing process. Did we now require this whole new amendments?
Yes, it is necessary in the sense that under our previous laws, even though we have an accused person can plead guilty to an offense, but in some cases the hands of the judge is already bound. Once you plead guilty, there are certain sentences the judge will have to just give it to you.
Within some parameters.
Within certain parameters, independent of whether you are being remorseful or you regret it or you want to even compensate the complainant.
Yeah.
The judge will not take into consideration all those factors. But with the plea bargain, a party can get to bargain even the sentence.
Yeah, and
With
this
the
time
prosecution.
it doesn't even include the judge.
Yes.
Yeah, because it's the agreement the judge adopts. But
is
the
so.
judge is not a party to the proceedings and the negotiations that take place. So, Courage,
Yes.
let's rewind back. Who can initiate this entire process? Then we come to what they are, because I want to go back to the fact bargain.
Okay.
I have a problem with that.
Yeah. So before I even answer your question,
Yeah.
we had some rudiments of plea bargaining scattered in our laws.
Yeah.
But as to whether we could actually see them or conceptualize them as plea bargaining, was that because the effect was not the same as what plea bargaining law is. And so if you look at the Courts Act, if you look at our own Act 30 and all that, even the Special Prosecutors Act, we have certain rudiments of plea bargaining and all that. So it existed, but the effect, like he mentioned, was that you couldn't even bargain certain things. I don't even want to use the word bargain. I always like to use the word negotiate, because if you want to go into plea bargaining, you start what we call a plea negotiation.
Yeah.
You negotiate there. Now, your question is at what point
And who initiates?
and who? Now, the parties, that is the accused person, and the prosecutor. So in this case, the AG, the Attorney General, and if there's the prosecutor representing the Attorney General. The accused person, the law requires that the accused person must be represented by a lawyer when the accused person decides to go into plea negotiation. Because it's very important for the accused person to be able to weigh the two and know which one is better off. So when it comes to plea bargaining, any of the parties can negotiate, initiate.
The accused, the prosecutor, or counsel of the accused.
Yes, can initiate the process.
But regardless, the lawyer for the accused must always be a party to the proceedings.
Yes, must always be a party. Okay. But you can initiate it at any time before judgment. Okay. Because once judgment is given, there is no way you can invoke that law or a right, if I may say.
So in initiating, I know for a fact that regardless of who is initiating, you need clearance of the Attorney General to proceed with these negotiations and to conclude them as well. But as a matter of morality, we all know that this happens in the criminal space. We know that offenses, criminal offenses are against the state as well, primarily against the state. Now, the accused person is negotiating with the state. Where does the input of the victim come in? Would the victim be considered? Because we've seen the parties in this negotiation.
Yes, the victim will also be a party to this negotiation. Remember, before even you go into the negotiation, there must be a full disclosure of the offenses and the evidence gathered against the accused person in order to enable the accused person to make an informed decision. Now, once the plea bargain, or as my learned senior will say, that once the negotiating commence, what we need to do is that the prosecution will inform the complainant, and the complainant will be a party to this negotiation.
Now, so does the consent of the victim or complainant matter?
Sorry to cut in. It doesn't matter in a way. Let me put it this way. So the law, because it is an offense against the state, and it is between the state and the accused person, the complainant or the victim is involved in the negotiation. However, if the complainant or victim has an issue, that is an objection to raise, the law allows the complainant or the victim to make a statement, and that statement will be attached to the agreement,
the final agreement,
the final agreement, and handed over to the judge. Even at the point of where the judge comes in, the judge will still ask the victim or the complainant as to whether he has any objection so far as the bargain is concerned. And at that material time, he's given another opportunity, if he did not raise any objection,
to put that in.
Now, the reason is to allow issues of restitution and compensation be made available to you, the victim. Because remember, in our criminal jurisprudence, even if a complainant decides I'm no more interested in the matter,
the state can still proceed.
The state can still proceed.
I mean, to that extent, I get that. I know that victims or complainants will be involved because, yes, there's a conversation about compensation. And because criminal proceedings usually end up with punishments in the older way, they will either jail the person or fine the person, and all those fines go to the state. You now have to initiate a civil process to be able to get your own compensation. I see what it does here, where inbuilt in the plea bargaining law is that opportunity to just make it a one-stop shop, where you negotiate, you admit to your guilt, you agree on some terms, and offenders may even end up paying more to victims, because at this point you are dealing also across the table with them. You've seen it's an actual human being that you hurt.
Even the whole process is done in a manner that what they agree on is not final. The judge has a role to play. The judge doesn't have a role to play when it comes to the negotiation. But when it is submitted to the judge, then the judge has to establish if there are factual basis. If there are no factual basis for the parties to enter into plea bargaining, then the judge will reject it. In that you can see that this is a matter that the facts doesn't even support the charge.
Yeah.
Or the evidence, they actually have the evidence. So there's no need even going with plea bargaining.
Okay, so you're mentioning two different legs to it.
Yes.
And one aspect, it helps the accused person. The other leg helps the prosecution.
Yes.
So the first leg is where the facts do not support the charge.
Yes.
So in your haste to be free, some people just are tired, they are scared, they are intimidated by the legal process, right? So they just don't want part of it. They want it over and done with.
Yeah.
So based on that, they go into this plea bargaining agreement.
Yes.
And then the judge says, look, even if you had come to trial, this wouldn't have gone through because you could have submitted no case.
You will go free.
Made a submission of no case and it would have been upheld.
Yes.
Okay, and then there's the other side.
The other side is that the prosecution actually have overwhelming evidence, to prosecute you. So why do you want to go into plea bargaining? Because others have seen it as it shouldn't be abused or it shouldn't be a system for people to, in a way, enter into certain corrupt practices.
Deals, yeah.
So the court or the judiciary is seen as playing a supervisory role in ensuring that there's transparency in the whole process.
Let's go back to the point where he talks about the fact that the case is watertight or airtight in a way that the prosecution could have gone through with a full trial and succeeded, and so a judge might not approve this. Shouldn't it rather be where the conclusion of the deal, in some jurisdictions they call it a plea deal.
Yes.
But if we call it a deal here, then it becomes a scandalous arrangement. But shouldn't it rather be a situation where they look at the final agreement? For instance, if the offense you committed, ordinarily you should go in for a term of imprisonment between 5 to say 15 years. Then you do a plea deal or plea negotiation. You negotiate it down to 5 years, which is still within the legal, parameters. Why would a judge say no to this? Because the outcome would have still been within this range.
Now, we need to understand even in the first place, before the prosecution will enter into a plea negotiation with you, there are certain circumstances that they consider. One will be the nature of the offense.
Okay.
Another will be the circumstance of the accused person. All these come into play before even the prosecution will even first of all start the negotiation. Now, I remember recently I did one, and the prosecution advised that, look, all what I'm saying, it should be put into writing to indicate the circumstance of the person, in that the person had health issues.
Okay.
And the charge against him is such that we are not guaranteed whether it will go for the prosecution or it will go for it's a 50-50 chance. And with this, the health of the accused person is deteriorating on a daily basis. And based on that, we are looking at it, look, let's just take the plea. Let's just take the plea. Now, when it comes before the judge is not bound to take whatever we have agreed on.
Yeah.
The judge will also look at other factors, whether the complainant has, if any, because not all criminal cases that we have a complainant, whether the complainant has some reservation to that effect, or whether even the facts in question support the charge in the first place. Now, if all these things are not in play, you don't expect the judge to simply just agree to whatever plea that just come before the judge.
And also, just to add to what he has said, if we are to go on the tangent of saying that we've agreed on 5 years, so we present it to the judge and the judge must go with the 5 years, then it means that in a way we are taking away judicial power from the judge.
Discretion.
Exactly, because that the exercise of judicial power lies within the judge. That is the judge's sole mandate.
Yeah.
So sometimes the judge may even consider the public interest or outcry in that matter. So it will be difficult for the judge to say, I'm giving you 5 years, when everybody feels that,
looking
this
at what
matter
you've done.
shouldn't.
Yeah.
You see, so I remember that when this whole process was going on, there was a big debate as to whether can they even decide to say, okay, 5 to 10. They decide that 4 years, because in some countries they do. For instance, in India, any offense that is more than 7 years, you don't plea bargain.
Okay.
In Kenya, sexual offenses, you don't plea bargain. So when the judge rejects whatever you've agreed on, sometimes the judge can even reject the charge, or even reject the facts, or even reject the sentence that you've agreed.
As in the agreement, yeah.
Exactly. And all they have to do is that to go back and renegotiate the process. So usually you inform the court. The court or the judge will give you 30 days to go and negotiate. So the case will be adjourned. Then once you conclude, then you come back.
So hold your thoughts on this. We'll go for a quick commercial break. When we come back, we continue the conversation. This is Law Express. That the negotiations in a plea bargain situation must be kept confidential. Must remain within the parties that need to know for obvious reasons. But I've always wondered, what if you propose this process, you have a conversation, which will require that you do some disclosures necessary to the negotiations, and then getting towards the end of everything, prosecution or the state says, we're no longer going to negotiate with you. Is there any anchor for somebody, an accused person who is giving his all in good faith, done his full disclosure?
No, you see.
I'm looking at the risk, because somebody watching us who has a charge over his head and is probably considering a plea bargain will want to see the possible downsides to it. And you can tell me this new law is 100% okay without any cons.
Yes. You know, just like any other man-made law, we have some lapses in relation to the law. But remember, this exercise of plea bargain negotiation, remember, the key word there is a negotiation.
Yes.
It is in the exercise of our judicial responsibility.
But you expect good faith.
That is
in the process.
Yes, it is done in good faith, and it is in the excess of our judicial responsibility, not judicial power.
Okay.
And remember, everything that is being said during these negotiations, you cannot come and hold me to those things in court.
Perfect.
Negotiations can break down, just like any other negotiation, and it can also go through.
So it's good to stress that this is all without prejudice.
Yes.
Very well.
Because
yes.
if you don't put it out there, people would wonder. That they come, they make full disclosures in good faith, and then some. So they could even, it could become a bait, where prosecution says, "Oh, let's go into these negotiations to pick more from you," or even the accused person's lawyer can say, "Let's go into a plea bargain negotiation," and then when they realize that this prosecution's case is not strong enough, then they withdraw and decide that they will go to trial.
So like you just mentioned, once you make admissions during the negotiation period, or you can't turn around and use that against the accused person. It means you have to proceed on full trial and prove your case beyond reasonable doubt, and all that. But there's a point that I think we've skipped. Plea bargaining law as it exists in Ghana today does not apply to all offenses. There are certain offenses that are excluded: murder, attempted murder, genocide, treason, because of the constitutional basis and all that, piracy, robbery and all that, several of them, kidnapping and all that. And it's important that we note that.
We sampled people's opinion on the topic today. We would take a listen and react to say.
Okay.
plea bargaining, the accused enters into an arrangement where he or she agrees to plead guilty for a lesser sentence or a lesser charge. And I think that whether plea bargaining represents guilt is it's a 50-50 opinion, because in one hand, I think that when you accept a plea bargaining, it's a smart way to avoid a longer jail time. But for maybe someone who does not want to compromise his or her morals, and let's say the person is innocent, but also knows that if trial starts, it's going to be lengthy, the person will still not agree to plea bargaining just because he or she wants to prove that he's not guilty.
Plea bargaining in law means an arrangement between the prosecutor and the defendant, whereby the defendant pleads guilty in order to reduce the charges or for them to withdraw the charges. Plea bargaining, I think, saves time and also reduces the sentence. For instance, if you were sentenced for like 10 years, it reduces to like 5 years. Yeah, that's what I think about that.
Okay, so plea bargaining is a situation whereby a defendant pleads guilty or pleads guilty to a lesser charge in a case of multiple charges to get a lesser sentence in court or to shorten court proceedings. People engage in plea bargaining because they believe that when they don't, the court proceedings are prolonged and they might get a higher charge for the crimes that they might have done or not. Others also believe that when you practice plea bargaining, you end up preventing justice from being served. Yeah.
I think they've said it all. It looks more like they know more about.
They know some of it.
Yes.
It wasn't exactly accurate, was it? Not in all instances.
In some way, the essence of what it is, they give out the idea and all that. So yes.
Well, they seem to know a bit about plea bargaining. However, there are a little bit of misconceptions.
Yes.
Most of them are simply saying that for a lesser sentence. Usually, the whole idea of plea bargaining is not necessarily for a lesser sentence. You can go series of ways. You can either plead guilty to a lesser offense. You can maybe go into a plea negotiations to compensate the complainant, and you can even go into a plea negotiation for some other benefit, which is at large. However, is subject to the parties on the negotiation table.
Yeah.
So they also have to understand that it is not in all offenses that a party can go for a plea bargain. They didn't capture that bit of it. They should also understand that some offenses are completely excluded. You cannot go for plea bargain issues of murder, attempted murder, kidnapping, and others.
Yeah.
So they need to also take that into consideration. But overall, they've done a good job.
So let's say you've been arrested and charged.
Before you continue, there was something you mentioned that you were going to come to, the fact bargain.
Yes.
Yes.
That's where I was going now, so you can just pick it up.
Okay.
Yeah. I've been wondering about this fact bargaining thing, where you choose not to disclose everything. What's the essence of this? Shouldn't full disclosure be the basis upon which this negotiation proceeds?
So the fact bargain has to do with the fact that prosecution decides what to present before the judge.
Yeah.
Because the facts determine the charge. So if I decided to break in, stealing, or robbery, then decided to cause harm to you and all that. If they
To somebody,
to someone, if they present all this, the judge will more or less be guided to
It's
direct.
not a suppression of facts.
Yes, yes, but
Technically.
but the person has admitted to the fact that, look, yes, I'm guilty, but instead of us going for 2 years, 3 years trial, look, let's leave the assault aspect. Take it out. I did not assault her.
I don't know. Like I said from the beginning, I have a challenge with the facts bits, the
Yes,
negotiation of that.
Because the robbery will give the person a higher sentence.
Absolutely.
Yeah, so let's just agree on the robbery and let him go in for robbery and forget about the assault and breaking in and stealing and all that.
But those are facts. They occurred.
What you need to understand is that we hate the crime, but we don't hate the person.
Hmm.
At the end of the day, the person is also a human, and there are certain circumstances that may have triggered all those events.
Lawyer of the accused.
So a party, yes, have committed a crime.
Mm-hmm.
The society frown upon such crime, but that person, we don't hate the human being. We don't hate the human being. That's what we need to understand from day one. We hate crime, but we don't hate the person.
Yeah, but even sometimes we have what we call the group crime and all that, and you just need one person to use as a witness. Although you are even prosecuting that person, you bargain with that person that, look, it's not, you are not the main target. I want the leader, but you have all the leads, you have all the information. So you know what? If I present all these facts to the court, it means that you yourself cry, you might be guilty as the leader.
Yes.
So let's keep this aspect of it out. You help us go after the bigger fish. Then, so
it's like you are the snitch, where you go, you give the facts
Not
and save to save yourself,
No.
and then you
maybe
bring the rest of the
I'm
crew
just
out
giving the
there.
facts so that in the end maybe I get on 3 years.
But what we
Instead
also
of bringing
need-
out the entire facts.
Meanwhile, you're just as guilty as everybody else.
we have
I'm
to-
helping the state.
How nice.
I'm helping the state.
Just because you were caught first.
But I'm helping the state to
Remember,
go after the
the
bigger
prosecution will still need eyes and ears on the field.
Yes.
You cannot go into investigation starting from nowhere. There must be some kind of
Great.
navigational
So
tool.
negotiate with the mole. We get that. Great. we have to go check out some social media questions. But before then, let's quickly put this into another, a clearer perspective. You have been charged. Well, you've been arrested, charged. You've negotiated. Okay, you have a plea deal or plea bargain. Okay, it's as if it's a marketplace when I use the bargain bit, but that is for another day. And you have an agreement. What should be in the agreement? And before it's signed and presented to the judge, what are the steps that ought to be followed? Just quickly.
Okay. So the agreement, the content of the agreement.
Yes.
First, the agreement must spell out the terms. The terms must be clear. The facts of the case is very important, and also the admission being made by what the accused person must also be there. Then the accused person must also, it must be clear that he pleaded to being what, guilty.
Okay.
Then
But first, he was informed of his rights before even the agreement.
So I'm talking about the content of
The agreement itself.
the content first.
Yes.
Now, once the judge looks at the content, the next thing is the judge should now move on to find out from the accused person whether he was informed of his right to what? A full trial.
Okay.
And that, did he alter that? Was he part of the process? Was it done voluntarily? Was he coerced and all that? So once the judge is satisfied with that, then the judge can then proceed to see if there are factual basis
For it.
for
Okay.
it.
But before then, it has to be in writing, obviously.
Yes, it has
And
to
it
be in
should be
writing.
signed by the accused person, the prosecutor,
Exactly.
and the lawyer of the accused person.
Exactly.
Great.
It has to be in writing, and it has to be signed. And even again, the judge must even find out whether the prosecutor has obtained authorization from the Attorney General.
Yeah.
That is very important. It's possible that the prosecutor obtained authorization, but during the negotiation, that authorization was
withdrawn.
revoked or withdrawn.
Yeah.
So it means that the prosecutor or the accused person cannot proceed to negotiate and reach any form of agreement or arrangement. So the judge has to look at all that, find out whether there were disclosures being made, full disclosure was being made, that the accused person had everything available to him in terms of the evidence that prosecution intend to use against the accused person, so that the accused person can make an informed decision as to whether to proceed with a full trial or
not
to plead what? Guilty.
Yeah.
And the question has always been, if the accused person knows that in the end, if we agree on 7 years, the judge will make it 14 years, then why do I have to waste time and get to the tail end and the judge will say, no, look, 7 years is too small, let me give you 14 years. At that point, the accused person has the right to what? To reject. Obviously, he will reject.
Let's go for the questions.
Yeah.
When we come back from there, let's look at the issues of the jurat.
Okay.
Yeah.
Dear Noella, my name is Kwasin from Takrade, and I'm curious about plea bargaining. If someone agrees to plea bargain, does it mean they're admitting they did something wrong? How do courts look at plea bargaining and innocence? I'd appreciate any help understanding this. Thank you.
It's an admission of guilt. It means that you are wrong. You want to say, look, I'm wrong. I don't want to go on a full trial. So let's look at how we can do this in a very nice way. Sorry to say, in a safe
way.
Time, cost, and everything, and I still get punished. And the state.
I think the only advantage here will be the fact that you can get to negotiate on what charge.
Exactly.
Once again, but at the end of the day, you're still guilty to something, and you are a convict.
Yes.
And the interesting aspect of plea negotiation is you taking responsibility of your own action. And that's why you will you either plead guilty to the same offense for a negotiated sentence or some other charge.
Yeah.
Yes.
Hi Noella, I would like to go anonymous. I recently read about a case in which someone was falsely accused of a crime but chose to plea bargain to avoid a lengthy trial. Now, my question is, how does plea bargaining affect the public's perception of someone's innocence or guilt, especially in a high-profile case? Additionally, are there specific guidelines or ethical considerations for legal professionals when advising clients on plea bargaining?
I think what the person is saying is not wrong. Yes, there's this whole public outcry when it comes to plea bargaining. People feel it's an avenue for an accused person to just walk away free and all that. And people always feel that, look, the person must face the full rigors of the law and must be punished.
In the manner they want.
In the manner they want. But again, there's something that the public usually forget.
Yeah.
That is, prosecution must prosecute beyond reasonable doubt. So
There's still
sometimes,
standards.
yeah, there's a standard. So you, the public, may just see it to be something easy for prosecution. There is something that may take prosecution years to even get or succeed in prosecuting that person. So going,
you know, we've even left out the issue of technicalities.
Yeah.
You see, you might have a case lined out and great for the prosecutor, but some technical mistakes, wrong charge, for instance, could just throw the thing off.
Yeah.
And then the accused person walks.
And even the manner in which the evidence was obtained.
Exactly. Or even stored and reproduced.
Exactly.
You know, contamination of samples and all of that. So based on all of this, if there's an avenue for a plea bargain, then what you're suggesting is that the person still gets to be accountable for their conduct.
Yes.
And what I will add is that a lot of people don't understand how the law operates. When somebody is charged with, let's say, stealing, there are certain elements that the prosecution must prove, each and every element. And it must be done beyond reasonable doubt. And it is not
simple.
An easy thing that you can just sleep and then wake up and say that, okay, I'm able to establish element 1, element 2. No. So when the option brings itself, it is a good avenue for both parties to save some cost and time. Because at the end of the day, it's still 50-50. You are not guaranteed about the outcome of the courtroom.
We call it like staking your bets.
Well, it's like,
you are hedging it technically because you do not know if you go in or not. Let me just agree and take a less sentence so that I don't go through the psychological trauma of the procedure, the right of the case. Let's talk about the appeals.
Yeah.
We all know that with plea bargains or plea bargain agreements, or plea agreements, I should say, you cannot appeal those.
Yeah.
They are watertight, right?
Yeah. So the conviction and sentence is final.
Yeah.
Because you have agreed to 7 years. If the judge adopts
voluntarily,
decides I'm going with the 7 years, then
that's
the conviction the sentence becomes what? Final, and you can't appeal against it.
What about issues of fraud?
However,
misrepresentation?
you can only do so if there are certain vitiating factors: fraud, misrepresentation, the rules against natural justice, and how it was obtained, and all.
Even the procedure, the process.
Yes.
If they didn't check all the boxes.
Exactly. If the procedure wasn't duly followed and all that, then you can appeal against that.
But would that not just be like saying, set it aside and let's start from the beginning?
So exactly. So you are setting aside. You start.
And start again.
Yes.
And probably you've served 2 years already.
Yes. So it's not as if you are free.
I wonder if people want to do this because you're going to start again and you could get a harsher sentence.
So it's possible I can start again and you may go free.
You may go free.
And you go for compensation for the 2 years that you've been in jail.
Here we go again.
And you see, in our jurisdiction, when you are having interview with persons that have been convicted, some of them will tell you that the prosecution told me that, well, I should just go and plead guilty. They will ask me to go home, and these are issues of fraud.
Yeah, misrepresentation.
And misrepresentation. Now, if some of these things should come up and you allow the party to still continue to be in custody, then that will be you sitting on that person's rights. So therefore, the window of appeal will not be available for that person. If the prosecution during the negotiation there was no full disclosure of the fact, they withheld certain facts and then put forward certain facts.
To convince you.
To convince the person. All these things should not be entertained.
Can we talk about illiterates and visually impaired people who are accused of offenses and seek to negotiate? What must be added to this agreement to ensure that indeed they appreciate what has happened?
Now, this brings to mind the concept of a jurat. Now, what a jurat seeks to achieve is to ensure that this illiterate person or this visually impaired person that the content of the agreement was read to the person and that person appreciates the content of that agreement. And that is the purpose of a jurat. You cannot just say that an illiterate person signed something written in English. And an illiterate person doesn't necessarily mean that the person doesn't speak English. You can be an illiterate in a particular language. For example, if it's written in Arabic and you don't speak Arabic, then you are an illiterate person in Arabic. Now, in Ghana, we use English.
Yeah.
Now, if the document is written in English, this person is an illiterate. The person doesn't speak English, or the person is visually impaired. Now, the concept of jurat is to show that the content was read to the person and that person appreciates what was captured on paper.
In the language he or she
understands.
So it's even about the fact that at the very beginning, the process, he was made aware of the process. Even before you then read out the content to him. He's supposed to understand the very nature of what he's been involved in. So you explain the process to him, everything, in a language that he understands. And I used to have a problem with the word in a language that he understands because it depends on the one who's also.
How do you prove that the person did justice to that process?
To the language.
It takes me back to Nelson Mandela's funeral, where somebody was signing.
Exactly.
And it later emerged that everything
all of
was off.
All of us.
Just to
the
bring
whole
this,
world.
a party came to say that he only speaks Zabrama.
Okay.
And it has taken us more than 3 months to even
to
get
find an
a
interpreter.
Zabrama interpreter.
That's a smart one.
Yeah. Till date, we are still looking for a
And
Zabrama
funny thing,
interpreter.
when you bring somebody who speaks Zambrama, this guy will say this language. He
This
doesn't
is not
really
a variety.
understand. This is not
You
the
know,
Zambrama that
even
he
even with
understands.
languages, somebody might understand another version. So this
Exactly.
is not the one I
It's
speak.
true.
This is too thick for me.
so it's that too is very important. But one thing I would like to just add is the issue of a juvenile.
I was going to ask that next.
Yes.
Because is there room for them to have this option?
For them, they are entirely being handled by the Juvenile Justice Act because of the fact that you can't go beyond 6 months trial and all that. So they decided to just make sure that the Juvenile Justice Act handles what offenses involving what a juvenile or and all that. So
minors.
Yes.
Generally.
Exactly.
And we should add that for a juvenile, it's always about the best interest principle.
Yes.
So that should always be the thing.
And
at
that
any
would
point in time.
encapsulate this entire plea negotiation, because if they are looking out for the best interest of a child, it means it's already inbuilt there.
Yes.
Where they can have a conversation, the child admits it.
Exactly.
They decide if to whether to put them in custody at the Bostal homes or to leave them at home and let them, go through some other means of setting them right.
Generally, what we need to understand is that once an accused person commences this negotiation process in relation to plea
with all
bargain,
the other parties.
with all the other parties, you need to notify the court that you have commenced a plea bargain arrangement, and the court may adjourn the matter to allow the negotiation to proceed. However, the law is such that if the negotiation couldn't be completed within a period of 1 month, the trial can still continue. But all is at the discretion of the courts.
Yeah.
Yes.
Yeah, I think there's one thing that we've left in the, if the agreement is presented before the judge has 2 options. It's either to accept or reject. Now the law requires that if the judge rejects the plea agreement, the judge is supposed to enter or record that he or she has rejected the agreement and give reasons why the agreement has been rejected.
Okay, which could inform a renegotiation or not.
Or not.
Yeah.
And that does not prevent the parties, or that will not prevent the parties from going back to what? To renegotiate the entire process. So once it is rejected, it means that that is it. You have to start the entire process again. However, you cannot appeal against the judge's decision to reject the plea bargain.
Yeah.
You can't appeal against that. All they have to do is to go back and renegotiate by way of starting the entire process again.
And that is if all the parties are willing to do that again.
Exactly. And also the fact that the parties can at any point in time before judgment is being given decide to withdraw from the process.
Yeah.
So the accused person at a point can say, look, I think if I go on full trial, these guys will not get me.
Yeah.
So I've studied their evidence, and I think I'm better off not going into.
It's also important to know that the fact that you have proposed the negotiation does not mean every party will agree to that.
Yes.
So if the accused person says, let's negotiate, the AG can say no.
Exactly.
If the AG proposes it, the accused person can say no.
Exactly.
Similarly, you can start at any point of the trial to stop proceedings and then have these negotiations. And you can always stop at any point too.
In some countries, it will interest you to know that once prosecution closes its case, you can't enter into plea bargaining.
But
so
with
you
us,
can't
you
wait for prosecution to finish
so
the
they
whole
check
show.
all their evidence.
Unless we still have more space.
Then when you realize that this is a big problem for you, then you now come forward to say, oh, can we? But the truth is, by the time prosecution closes its case, they know if they've presented a solid case. So if the accused person runs forward to propose a negotiation, then they know the person is in over his head.
Yeah. So
would they be open to that?
They may be open to that, but it will inform them as to the final agreement they will reach with the accused person.
Well,
for us, it's open till, so at any point in time you can decide to initiate the process.
I think prosecution might agree where, for instance, the accused person has lined up 45 witnesses, which would take 5 years to clear.
Yes, exactly.
They could still be open to that.
Even I remember the thinking that went into it. In that, for instance, there are instances whereby an accused person may have a lawyer who has, in a way, ill-informed
his clients.
That look, let's proceed on full trial. Then later on, he changes
the lawyer.
And the lawyer comes in and be like, look, this is your matter. If I look at it, look, this, and that. The accused person should still have that chance of going into a plea bargaining, even when prosecution has closed its case. So that is the thinking that went into
makes it open,
as making it very open for prosecution and the accused person.
In terms of the timelines.
Exactly. Yeah. But you must do so before judgment is delivered.
Remember, you don't even know the extent of the accused person's defense.
Yeah.
It may simply delete everything that you had come to establish. It will raise some reasonable doubts.
And then deflate
and
diffuse your case. Our discussion today has been on plea bargaining. My name is Noella Seidu, and my co-panelists have been Mumin Mashoud and Courage A. Asabagna. Goodbye, and this has been our show.